Guys? Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this Honorable Court.
Please be seated. We'll hear argument in 4 cases this morning, 2 of which are consolidated. First is 2999, Texas Health and Human Services Commission against Pope from Travis County and the 3rd Court of Appeals District. The court has allotted 20 minutes for each side in that case. Then second, 2 consolidated cases. First, 21-518, the City of Houston against Houston Professional Firefighters Association, and 21-755, Houston Police Officers Union versus Houston Professional Firefighters Association. Both are from Harris County and the 14th Court of Appeals District. The court has allotted 30 minutes per side. In those consolidated cases, Justice Huddle and Justice Young are not participating in the decision of those cases. And then finally, 21-784, Fraley versus Texas A&M University from Brazos County and the 7th Court of Appeals District. The court has allotted 20 minutes for each side in that case. The arguments are being webcast live this morning and will be available later in the court's archives. We'll complete the arguments before lunch. Justice Lehrman cannot be present this morning, but expects to participate in the decision of all of those cases. We're ready to begin with argument in 2999, Texas Health and Human Services Commission against Pope.
May it please the court, Ms. Pettit will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. Throughout this litigation, plaintiffs have been remarkably imprecise about the questions that are normally at the heart of any whistleblower claim, namely who said what, to whom, and when. For good reason. Their primary claim has always been that they were fired for repeating a report made for the first time years earlier that a contractor had violated a particular Medicaid regulation. But the Whistleblower Act expressly excludes reports of misconduct by contractors. Plaintiff's secondary theory that they also reported that the same contractor violated a different regulation cannot bridge that gap. Now, unless the court directs otherwise, I'm going to focus on the parental accompaniment reports because until plaintiffs responded to HHSC's motion for summary judgment, those were the only reports that they had asserted led to their termination. Whether those reports fall within the narrow scope of the Whistleblower Act's waiver of sovereign immunity depends, as this court reiterated just last term in Pridgeon, on the language the legislature chose. And since 1995, the legislature has chosen to limit those protections to reports of violations of law by the employing governmental entity or another public employee, both of which are defined terms. Taking them in reverse, the public employee definition, again since 1995, is of an employee or an appointed officer other than an independent contractor being paid to provide services to a state or local government entity.
Do you agree that the call center employees that were the subject of one of the reports would qualify as public employees?
Yes, Your Honor. However, as the third court implicitly recognized in its causation discussion, there is a time gap between that report, which occurred in February 2014, and their termination in 2017 that would make a claim based on such a report fail as a matter of law. Moreover, that date is significant because between 2012 and 2014, there was significant flux on the requirements of the parental accompaniment rule. Indeed, as Grace Windbigler explained on page 153 of the clerk's record, due to ongoing litigation, the rule that is the primary focus of this report wasn't actually enforceable until 2 months after that report was sent. And interestingly, I'd like to, taking that as a foil for the main theory that the Court of Appeals relied on to find a report here that continued through 2017, was the notion that by reporting to the violation of LaFleur, who, again, is an independent contractor and therefore excluded by law expressly from the statute, they must have also understood to be report by HHSC because one flowed into the other. But that report actually showed that LaFleur was manipulating the system, that the call center employee was confused, but that LaFleur was encouraging parents to call over and over again until they got the answer they wanted. That is not a report reasonably understood in context about HHSC. Instead, it is a report forwarded to HHSC's OIG, apparently to enforce on HHSC's behalf. And that is the significant problem with the Court of Appeals' reasoning. HHSC is, because of the function of Medicaid, every bit as much a victim of any fraud as the federal government.
When HHSC makes a report to the federal government and says, I've paid this to LaFleur, I want reimbursement for these amounts, is there any sort of representation or certification or anything that occurs that these charges that we're seeking partial reimbursement for were incurred, in accordance with federal regulations or the state Medicaid plan or anything like that?
So there are a number of forms that go into CMS. Typically, I believe it is a CMS 64 and a CMS 37. And they do make similar representations to what Your Honor is suggesting. However, they aren't functioning the way that the plaintiffs suggest, because Medicaid is a very complicated statute that involves, as Bowen against Massachusetts from the U.S. Supreme Court explained in the 1980s, massive transfers of funds on a quarterly basis. And it's not uncommon for people to accidentally, inadvertently, or otherwise claim amounts based on what they think they are entitled that they have to adjust at the end of the year. And that is where we have the missing link here. By reporting about LaFleur, they don't necessarily get to report about HHSC unless some sort of corrective action was not taken. And that is and under this court's cases in Luke, that is what happened at most was a prediction of future regulatory noncompliance, which isn't a violation of law by HHSC. This court reiterated that conclusion in City of Elsa. So that report, that's the first of, we've done the first and second of, I think, 3 total theories that the plaintiffs have suggested about the parental accompaniment rule, that they had appropriately reported a violation by HHSC. The third, and what the third court relied on to show causation, because again, a lot of these reports were for conduct were in 2014, was statements in 2017 that these reports had been previously made to HHSC and an implication that HHSC had not done enough. Now, that itself runs into problems, again, under Luke and under Pridgeon, because as this court said in Pridgeon, to be a report, the information doesn't have to be a unique disclosure, but at some point the information becomes stale. And it is simply repeating, it's not providing additional information other than an opinion about a violation or an opinion about, in the words of Luke, whether or not an appropriate remedial action was taken to a known problem. And that is what 2017 reports are, and I'm going to point specifically to a letter that the plaintiffs have said was their primary report because it was a letter to CMS about whether or not they were entitled to funds. That letter was about fiscal year 2011. It was not a report about anything that was happening in 2017. And the content of that letter, even after the plaintiffs made their alleged reports, still said that HHSC was entitled to the funds. So at most, these letters are not providing any additional information. At most, these were edits about whether or not there was documentation for particular factual statements in the letter. The plaintiffs said they couldn't find any 6 years after the fact, HHSC took the comments out, and they sent the letter on. But
Just the temporal distinction, though, I'm not following you, because if it were if you had a hypothetical case where someone was reporting new information about a violation of law that happened 6 years ago, if they're reporting it now, there's no contemporaneous connection problem cause-wise, right? Just because the conduct occurred a long time ago?
there is not necessarily, but it does depend on whether the governmental entity was already aware of the issue and whether the report, again, as in the term that Pridgeon used was stale, or as Luke said, was about whether a sufficient remedial action had been taken to respond to a known regulatory problem. And that because, as the court said in the city of Elsa and in Barth and in other cases, a violation of law does not include a disagreement about policy. And in particular, doesn't mean a disagreement about enforcement policy, because state agencies, since at least State against Malone Services in 1992, are recognized to have a presumption of enforcement discretion, unless that discretion has been removed by the legislature. And it hasn't been here. To the contrary, the primary provision that plaintiffs have relied upon to show that there was a duty to enforce this and a duty to prevent fraud is Texas Government Code 531.102. And in particular, they refer to subsection A and subsection A-5. But if you scroll down to subsection B, that provision specifically re-ups and reaffirms HHSC and OIG's enforcement discretion. HHSC's commissioner and OIG are supposed to work together to set enforcement priorities that consider, among other things, the likelihood that a particular enforcement action will return funds. That enforcement authority is also reiterated in subsection G, which is about payment holds. So under those, there are specific things were to be considered, for example, G, 8, B, and D, about whether or not an enforcement action would prevent Medicaid recipients from having access to care. Because ultimately, what federal law requires is that the state provides certain benefits to beneficiaries. And if an enforcement action, particularly a payment hold, would have prevented that access to care, then that enforcement hold was not appropriate. That is precisely the situation that was happening here. In an email sent by Ms. Pope herself on May 27th, 2017, and I would point you to CR 359, she noted that LaFleur was in financial distress. So what we have here was simply HHSC trying to make sure that an important provider was not put out of business by an enforcement action, and thereby the people in South Texas were deprived of the health care that they needed.
Returning to whether there was a violation of law, I sort of expected that I would find a clearer statement somewhere that HHSC paying for services that are ineligible or seeking federal reimbursement for ineligible services violates the law. Mm-hmm. And it doesn't seem that there's a clear statement in a statute or rule that specifically violates the law, but it seems like it must somehow or another. And I wonder, is it your position that making payments to ineligible services or seeking reimbursement for ineligible services just does not violate the law?
So I want to pick that apart out because there are questions of whether or not it is a violation of the state's rules regarding what people are eligible to receive and whether or not they are eligible for what's called federal financial participation. And so the allegation that they are relying upon to have a problem by HHSC is the federal financial participation. And so if HHSC submits a requirement, a submission for reimbursement, as Justice Busby asked on CMS 64, that is known to include things that are improper, then that probably is a violation of the law because they are not eligible for federal financial participation. But because of the way that the Medicaid formulas function, there are what the HHSC OIG statute describes as ordinary payment adjustments. So it's accepted that sometimes you're going to get your math a little wrong, or you're going to think that this was eligible and it turns out that it's not. And that gets adjusted at the end of the year in an ordinary course transaction, which is why HHS OIG is often the entity that enforces the law on behalf of HHSC and not necessarily against HHSC, which is why the third court was wrong to infer that simply reporting something to HHS OIG necessarily meant that they understood that there was a problem by HHSC instead of by a provider. And I realize I just used a lot of alphabet soup. So,
But HHSC is the state entity and HHS OIG is the federal entity, just to be
no, Your Honor. So when I refer to HHS OIG, although they do exist at both levels, the HHSC has its own Office of Inspector General, which enforces the law
Yeah.
on behalf of the entity. And I would point Your Honor to, I believe it is Texas Administrative Code 371.11, that entity actually enforces on behalf.
Right,
So-
I just thought you were referring to the federal one.
No, Your Honor. So I was referring to the state one.
I suspect your opponent's attorney is about to get up and say you're not correct, and that in fact there was a violation of law. Assume we agree with you that there was not in anything that the plaintiffs here raised. Do we also then have to conclude that it was impossible and is impossible for him to get up and argue to the contrary in good faith? Why could they not have believed that in good faith? And if we do have to find a lack of good faith, and you think it's impossible for that to be true, why is that impossible here?
So the good faith definition, as this court's reiterated multiple times since Hart, is an objective and a subjective inquiry. And the objective inquiry here is why they don't have good faith in this argument. Because Ms. Pickett is a lawyer. Ms. Pope had been running this program for years. And the objective requirement is based on someone who is reasonably in that position, whether they would reasonably have understood. Because of their level of expertise, the delta between what is a violation and what is a good faith violation is vanishingly small. Instead, here, the Third Court of Appeals reversed that rule and said because that they were so experienced, the court was going to give them the benefit of the doubt. That's not how this court's test works, and for that reason, the Third Court was wrong.
Well, I think we have a pretty good lawyer about to get up and argue to the contrary. Do we have to conclude he's not acting in good faith to rule for you?
I see I'm out of time.
You may answer.
You don't have to decide that that my esteemed counsel on the other side is not acting in good faith to rule for me. That's a different question than from whether his clients were acting in good faith in 2017. I have no doubt that he has I'm blanking on what the state rule is. That within the federal system, a Rule 11 belief that he has a good faith argument that he is correct. He simply is not.
Any other questions? Thank you, Ms. Pettit. We'll hear from the respondent.
May it please the court, Mr. Quinto Pozos will present argument for the respondents.
May it please the court. The court should affirm the Court of Appeals for two primary reasons. Number one, there are laws requiring, in this instance, that minors be accompanied by certain approved adults, that the agency use a capitated rate model, including the collection of an experience rebate in the provision of these services, and that the agency investigate fraud, waste, and abuse in providing these services. The agency was doing none of these things. And my clients reported these failures by the agency, and they were fired as a result. Secondly, because of the Whistleblower Act's good faith provisions, given the facts of this case, my clients are entitled to protection. I'd like to just give you a brief roadmap of my argument. I'll start out by talking about why my clients were fired. I'll talk about the laws that govern the transportation services in the state and how they were violated. Then I will talk about the good faith provisions of the statute. And finally, after some big picture considerations, I hope it'll be clear why the court should affirm the Court of Appeals. Even though causation is not at issue in this case. I'd just like to take a brief snapshot of the reason that my clients were fired. By 2017, this private contractor owed $5.6 million to the state, and the agency blocked my clients from trying to collect on that debt. They were told to stand down. In August of 2017, my clients told the Office of the Inspector General of past reports that they had made that were not responded to, that involved minors who were receiving services without the proper adult accompanying them. And they also told the OIG that the agency was standing in the way of the collection of the experience rebate that was due at this time.
Is voicing a disagreement with the remedial action that's being taken or not being taken, is that sufficient to be a good faith report that an investigating agency has violated the law?
Your Honor, this did not amount to a simple disagreement over enforcement. Everybody, it is undisputed in the record, everybody agreed with my clients that the money was owed, that the exact amount was owed. And my clients attempted to take action that was part of their domain, so to speak, to assess penalties, to garnish the payments to the contractors. And they were told not to do that. They were never told this is part of a larger strategy. We are trying to see if the contractor will fulfill its obligations before we assess these penalties.
And what requires the agency to tell them that?
Your Honor, I'm not sure that there would have been a requirement anywhere that the agency informed them of that. But that goes to the good faith question. If my clients had any information to suggest, oh, this is part of a bigger scheme, we don't know the bigger picture, that would have defeated the good faith provisions that I will talk about later. So I'm not sure that there was
Is that not inherent in the structure where OIG is the party that's responsible for enforcement? The subdivision of HHSC that's responsible for enforcement?
I would agree that, yes, that would be within the purview of the Office of the Inspector General. And my clients took steps to ensure that to make inquiries of the Office of the Inspector General to find out what was happening with these reports. At no point were they ever...
It sounds like you're saying that if HHSC had a reason, a good reason perhaps, for not pursuing this the way your clients wanted them to, that would not have been a violation of law.
Well, again, we're talking about hypotheticals here. I mean, yeah, potentially whatever that reason may have been, if that reason fell within the complex statutory scheme that we've heard about, that is a combination of federal and state authority, if that reason to hold off on enforcement would have not violated the law, if that would have been in compliance with the law, then yeah, my clients would have no standing here. However,
What are the laws constricting that discretion to hold off that your clients alleged were violated?
Well, Your Honor, the laws are, again, a very complex scheme at the federal and state level. We, talking explicitly about the capitated rate and the experience rebate requirement, that is found in government code and the administrative code. I don't believe that the statute or the administrative code, the regulation, dictates what discretion the agency has in terms of when to enforce a requirement, how to do it, whether to do it via litigation, via fines, etc. My clients were trying to apply the tools that they had at their disposal via fines, via garnishment of payments to the contractor, but they were told to stop. And again, so there's no information anywhere in the record to suggest that this was part of a larger scheme. And so,
I mean, that sounds a lot like, I don't like what my boss is doing. I wish they were behaving differently, and so I'm going to claim that that's a violation of law. And then if I get fired over the disagreement, it's a whistleblower claim. I mean, if you're conceding that there's some discretion not to pursue the recovery of the money, then how can you distinguish this from just a disagreement about how to handle a situation over which the agency has discretion.
Well, again, I think if nothing else, Your Honor, that takes us back to the good faith question. Again, as far as my clients could see as experienced administrators and as the people trying to enforce these requirements, there was nothing that the agency was doing. And
Well, is your allegation that there was some sort of corrupt motive for not seeking the reimbursement?
the plaintiff's allegation was that the contractor was trying to triangulate, go above their head directly to the top of the agency via their lobbyists.
Well, they were exercising their constitutional right to seek redress of grievances. I mean, they can go to whoever they want to go to and try and get what they want from the agency, and that's why the agency has a hierarchical structure.
My clients, there is no evidence in the record, and my clients make no specific allegation that either the contractor or the agency was acting with a corrupt intention in mind. Their allegation was there are these clear enforcements in the law to operate the transportation system in this particular way, and we're not doing it. But because we're not collecting the experience rebate, it's clear in the law that the capitated rate model requires that as part of the administration of the transportation services. And it's simply not being done. And we are the people who know about it because we are the ones who know the exact amount that is owed. We know the tools at our disposal to try to collect this debt. And none of that is happening.
But your clients knew that the agency had discretion and there could be an overarching plan. Even if they didn't know in fact and if they didn't know what it was, they knew as experienced administrators there could be a plan.
Your Honor, I don't believe that there's any specific evidence in the record that there was any information available to my clients with regard to this situation or in general that there was discretion at play here.
Well, but you're arguing here the agency did have discretion. It could have had a plan.
Your Honor,
Your clients just weren't told what it was.
Your Honor, it is possible that the agency had discretion. It is possible that this was part of a larger scheme within the agency's breathing room as to when to enforce these requirements.
But your clients, being experienced administrators, knew that.
Your Honor, again, there is no evidence in the record that this was what was happening, and there was no evidence in the record that my clients were aware that it was discretion at play that was explaining the agency's inaction. And certainly they were never told.
Would it have been their role, or would it have been OIG's role to handle the enforcement?
Are you talking about my clients?
Yes.
My clients had some tools available at their disposal, like I said, with regard to the experience rebate. We talked about the garnishment, et cetera. With regard to the transportation of minors without the legally required adult, they could do things like audits and spot checks. My clients did some of those things.
What about on the, and I understand that, what about on the issue of the experience rebate payments? Would it have been up to OIG to collect those?
Your Honor.
To enforce it if LaFleur isn't paying?
Your Honor, the statute is clear that under the government code, OIG is charged as the entity that investigates fraud, waste, and abuse in the provision of health and human services in the state and to enforce the laws of the state. But the law is also clear that the office and the agency overall must coordinate with each other to accomplish these missions. And in fact, the agency itself can impose administrative penalties as a result of violations. And so even though my clients, to get back to the earlier question, my clients could do certain things, but they didn't have the reach to get to all of these violations. Some of the violations included medical providers, doctors and therapists, providing transportation services themselves. That's against the law. My clients had no enforcement power over medical providers. And so even though they had some tools at their disposal, they didn't have the reach and the resources and the staff to do the magnitude of investigation and enforcement that was required in this case. We're talking.
Ms. Pope said in her deposition that that the experience rebate issue was not the violation that she was reporting, and that was the subject of this litigation. What should we make of that?
Your Honor, I believe that what she stated in her deposition, and I believe that Mrs. Pickett's deposition substantiates this. The thing that immediately preceded the termination was them speaking up to OIG in the context of trying to avoid this penalty from the federal government, in which the federal government wanted an attestation or a statement swearing that there were systems in place to avoid unlawful rides. My client spoke up and said, we've been researching this. Yes, the violations are from 2011, but we're doing the research now. We're not finding any of those documents. And no, we can't say that we followed the law. And so they were terminated just a few days after that. And so in the moment that the litigation was filed, my client's assumption was this had to do with the parental accompaniment requirement that has been a problem for the agency for a long time, and we just reported about again. However, in the course of the litigation, it became clear during this discovery, and Ms. Pope, I believe, explains this in her deposition, that the agency was answering a lot of the reasons or a lot of the context of the terminations had to do with the experience rebate. And as the timeline was being reconstructed, it became clear that that also had to do with the reason for the termination. And again, that is connected to earlier questions we were talking about regarding obligations by the agency to operate the transportation system under the capitated rate model, including the collection of the experience rebate.
So let's just assume for the sake of argument that we disagree with you on your assertion that the agency's inaction, your failure to pursue these things can be a violation of law. What's your argument that your clients reported actions by HHSC that affirmatively violate the law?
Your Honor, there is a lot of discussion, I believe, in the arguments at the trial court and the Court of Appeals regarding the provision of the transportation services. And some of the questions that we heard earlier had to do with the seeking reimbursement or accepting reimbursement from the federal government, making the payments to the contractors. Those violations were happening, as far as my clients were concerned, earlier in the timeline. Part of the distinction or part of a complication is that the funding model changed in 2014 or 2015, and the agency switched from a model, due to legislation that was passed, switched from a model in which each ride was being compensated individually, and then it switched to the managed care or capitated rate model. However,
So are you saying that the reports of improper payments are all pre-2014 and that the later reports would not have alleged improper payments by HHSC and/or improper reimbursement from the federal government?
I believe that the improper, the arguments that we've made, and I continue to believe this, Your Honor, is that the impact of the violations changed a little bit. The violations used to have a financial repercussion or a financial reward every time that there was an unlawful ride prior to 2014 or 2015. After that, whether a ride was legal or illegal did have a result or an effect on the capitation rate, and those rates were calculated 1 year for the year prior. And so it did have an effect on inflating the rates. But regardless of the compensation model, the administrative code is very clear that in order for a minor to be eligible for transportation service, he or she must be accompanied by an approved adult. That regulation makes no mention of the reimbursement, makes no mention of the rate, it makes no mention of the payment to the contractor. And so we don't have to have a situation where the payment or the reimbursement was the problem for the transportation services to have been unlawful.
But my concern there is that the payment and the reimbursement are what HHSC does, whereas the ride is what somebody else does. And so if we're looking for an allegation of violation of law by HHSC, it seems that we would look to the payment and reimbursement, which is what they're doing, as opposed to what some third party's doing.
Well, under the statutory and regulatory scheme, it's the agency that is and the Office of the Inspector General that are charged with the enforcement and the operation of these state statutes regarding the provision of these services. And again, the federal, because it's a combination of a federal and state legislative and statutory scheme, the federal government requires the state to operate the transportation system in a way that complies with these rules. And so even though it was, in some cases, or I believe in all cases, third parties that were providing the transportation services, if the state was not holding those providers to the law, then the state was not following the law.
But then we get to that question of discretion again. So, for example, an investigator recommends that a contractor be fined $500,000, let's say, for violations of regulations or not compliance with its contractual obligations. And he recommends that to the higher-ups at the state agency, and the state agency hears from the contractor, and the contractor says, well, we didn't violate the regulations. And if we did it, not nearly to the scale that this investigator found. And so we see it differently. And so at the end of the day, the state agency enters into a settlement agreement with the contractor where, you know, the contractor pays, you know, say $100,000 or something very small. Is the state agency liable under the Whistleblower Act simply because the investigator has reported a problem with the contractor and the higher-ups at the agency just determined to do something different to remediate it?
Your Honor, I think that takes us back to the question of good faith. If in that situation, if the whistleblower in this case is the investigator.
Yes. And I'm trying to figure out what we do. There's tons and tons of investigations that happen all across the state.
Absolutely.
And it sounds like what you're saying, if an investigator's recommendations are not followed in terms of enforcement against a third party or a contractor, that is tantamount to a good faith report of a violation by the agency.
That's not our position, Your Honor.
Okay,
Our
and
position,
so what is it short of that?
Well, Your Honor, I think that in your scenario, in your hypothetical, if this investigator had made this report and the report went nowhere, that would be, at least would provide the investigator with a good faith belief that the agency was not following the law, was violating the law. On the other hand, if the investigator was aware that there was a settlement, there was an investigation, there were mitigating factors as to why the contractor was not making the payments. And if given the investigator's experience and so forth, the good faith factors, that could defeat the claim, right? And so I think you have to look at the facts. And in this case, we had both an OIG investigator and the second in command at the agency say, if Mrs. Pope and Ms. Pickett or any agency employee suspects that this type of crime or fraud is happening, it is the job of OIG. We respond to those concerns. And so they acted, given their experience, 40 years of experience for Ms. Pope as an administrator and a licensed attorney for the program formerly. Given their experience, I do believe that the good faith gives them protection in this case. And so for those reasons, I would urge affirmance of the Court of Appeals below.
Any other questions? Thank you, counsel.
Thank you.
Ms. Pettit, you have 5 minutes.
Thank you, Mr. Chief Justice. Just a few points. The first is, at the beginning of my colleague's argument, he said causation is not an issue in this case. That's wrong. This court noted in City of Elsa against Gonzalez in footnote 4 that whether an issue was raised by a party in their briefing is irrelevant under the Whistleblower Act because the elements are jurisdictional and the court has a duty to consider them sua sponte. So let's put that aside. The second is that much of their argument today dealt with the experience rebate that, again, was added in response to the HHSC's pointing out the problems with their primary theory at summary judgment. So as a result, the record is very vague as to what they knew and didn't know. But that's a problem for them. This court said, we are not at a pleading stage, we are at summary judgment. And this court said way back in 1986 in Hudson against Wakefield that the non-movement has the duty to expressly present to the trial court any issue that would defeat the movement's right to summary judgment. And if they don't do that, they can't complain about it on appeal. That is at page 630, note 1. So, and again, the experience rebate, I want to pause there for a second because I didn't discuss it much in my opening argument, but it has the same problems because it is a violation by LaFleur. Section 353.3 of the Texas Administrative Code imposes the duty to pay on LaFleur. It does not impose a duty on HHSC to collect in every instance. And as the court has been discussing quite a bit today, there is enforcement discretion there.
And it's discretion by OIG, as I understand it, right? So any report of violation of law would have to be a violation by OIG specifically?
So the report here was to OIG. There could have been
Well, right, it was to OIG, but if it's a violation of law regarding enforcement, it would have to be the report would have to be of a violation by OIG.
Probably, right? But it depends, because the report on enforcement, if they are talking about, for example, an administrative penalty, might be OIG. Now, if it were a report, because there are other means of enforcement of all of the laws alleged here, including a lawsuit that was actually filed after the plaintiffs left HHSC, that probably isn't an OIG decision. That is probably a decision that HHSC makes, probably with consultation with OIG, but also in their general counsel's office.
I didn't hear you mention the argument from your brief today, and I just want to be sure that that this is still your position, that there still has to be an express report of a violation by the employing entity, and that a report of a violation by the private party is not sufficient.
Yes, Your Honor.
Okay, because it does seem like, reading the record in the light most favorable to the plaintiffs, that they were trying to keep HHSC in compliance with these requirements so that there wouldn't have to be this repayment, which indeed the federal government sought. But I take it your argument to that is that's not what the whistleblower statute is about.
Yes, Your Honor, because the whistleblower, as I started off my argument this morning, expressly excludes in section 554.001 subsection 4 reports by independent contractors, which is what Your Honor is describing. So and that's a really important point, and Your Honor brought up that they could have been going to HHSC's OIG to prevent HHS from violating the law. That is HHS OIG's or HHSC OIG's function in that circumstance. They enforce for HHSC. And so as a result, the Third Court of Appeals mixed it up when it said by reporting to them, they would automatically have known that they were complaining about HHSC. And that's just a disconnect that doesn't work. It also doesn't work in the larger context of this statute, which is that this is a retaliation statute. Everything that I heard from opposing counsel was that you could infer this, you could infer that. But it's not really retaliation if you have to make 3 different inferential leaps from the report to even know they're complaining about you.
So if they had said at the very beginning, and I recognize your point about this multi-step process of inferential chains to reach that, but if they had said, we think that federal law imposes a duty to not receive funds that we know are wrong. We're receiving these funds, that's wrong. I think that's a violation of law for you not to enforce. If they had said that, would we have a proper whistleblower claim?
No, for 2 reasons. The first one is that is an opinion, which is not a report of information under Pridgen. The second goes to the good faith.
So if you take out the word think, federal law requires this, you're not doing it, that violates the law.
So not for Ms. Pope and Ms. Pickett, because as my colleague on the other side closed off his argument with, they were experienced administrators, one of them was a lawyer. That is not a correct statement of the law, and it's not one.
Lawyers occasionally get the law wrong.
That's true, they do. But in this particular instance, that is so inconsistent with how Medicaid functions through this system of adjustments and repayments that is a normal process, part of the Medicaid process, that a lawyer of Ms. Pickett's experience or an administrator of Ms. Pope's would not have an objectively reasonable basis to think that was a violation of the law.
Any other questions? Thank you, Ms. Pettit. The case is submitted, and the court will take a brief recess.